Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and today it's my pleasure to review another book by Derek Roebuck. I've liked Derek's books immensely. They are really easy to read and they're very fascinating for anybody involved in both legal matters or for those historians amongst us who have an interest in this particular area of history, arbitration. Now, the book I'm looking at today is called Early English Arbitration. Been written by Derek Roebuck. It's published by the HOLO Books and the Arbitration Press in Oxford. And this book was sponsored by Dewey and LeBoeuf, if I've pronounced the name correctly. My wife Elizabeth and I talked about this book and the series of books that Derek has written, which are very high standard. And our review title is Arbitration and Dispute Settlement in England from Prehistory and Roman Times to the 12th Century. Now, I'll talk about the review in a minute. Let's have a look at the book, because these books are lovely. They're really nicely put together. There's a lovely front cover. There's the spine, and then there's quite a lot of decent information on the back there. In the inside, you've got a little bit about Derek on the front inside cover there, dust cover, and then other books published by HOLO Books there. I hope I pronounced right, HOLO or HOLO, I'm not quite sure how to pronounce that. There's the index at the back, and there's a lot of detail gone into this, and a huge amount of bibliographical information as well. Derek has really done his homework. The bibliography goes on for some time. There's a very useful chronology, which I've always found great. I'm a bit of a chronology man when it comes to my skeleton arguments and all the other things we do in court. But it does always give you a picture of what has happened from the year dot. He starts off from prehistory, of course, and then goes all the way through. Now, the actual content of the book itself is nice. You've got useful footnoting, which I found very helpful. And there's quite a lot of use of comments, for instance, use of Latin. And this is one of the appendices I'm looking at the moment. Language of dispute in England and before the common law. That's actually the appendix, the various appendices. But I think it's quite important to know exactly. Appendix A is what deals with the language, and then again you've got various other matters in Appendix B, which looks specifically, when I get to it, at the text of the laws of those two people. Now, I'm not going to try and pronounce their names. Now, Derek has given it a nice little dedication, which I always think is worth mentioning there. This is actually the front page. It shows some of the other books he's written as well. And what we've then got is the actual, there's a little bit of a little short note from the author, and then there's the content there, running all the way through, and you can see how it deals with the various different ages, if I can put it that way, running through logically. Then there are some conclusions at the end. Remember, we're dealing with a specific period of time here. Then there's a useful preface with a lot of detail in it. And of course the book is a little old now, 2007, December 2007 when he wrote it. A nice little map, a series of maps there to give a bit of pictorial information. There's a bit more there. And then we get into, very interesting, one of the first arbitration awards. And then you've got the book itself, and then you can see there's a lot of detail all the way through. It's a lovely book, part of a series, and I've been delighted to review them. This is what Elizabeth and I say anyway about the book. Derek Roebuck, who writes this engaging and erudite book that you can hardly put down, must be fascinated by fights, well, disputes actually, and even more fascinated by the ways and means by which disputes have been settled by arbitration in times past. There's evidently nothing like a journey into past history to put modern arbitration procedures into perspective. But you don't need to be an arbitrator to love this book. It should also attract general readers and history fans alike. After all, why immerse yourself in historical novels, they're fiction, remember, when you can read about the real thing? And you can't make it up, to use someone else's expression, Mr. Littlejohn. And if you do want the real thing, rest assured that Derek Roebuck does delve into an amazingly diverse body of original sources from the Bodleian, the Bibliotheque Nationale, Paris, and so forth, to construct as accurate a picture as possible of this diverse and detailed subject. And it's an important and a continuing subject, because we come back to arbitration quite often when we try to resolve disputes. The book itself has been published by HOLO or HOLO Books and the Arbitration Press in Oxford, and it takes us on a journey down the circuitous route of dispute resolution in England from earliest times to around 1154, when England's then new legal system, the common law, began to emerge properly. That's around the time of Henry II, and the concept of judges going around the country dispensing judgments and so forth. You've had a whole range of books, Glanville for instance, and a few others. So you had the beginnings after the Norman conquest of that coming in, of course arbitration being quite an important area. So the time period encompasses prehistory, the Roman to English period, the time of Alfred the Great, King Canute or Knut, and eventually the Norman conquest and beyond. So you've got a fairly nice little series of snapshots going all the way through, and that's done on a chapter by chapter basis in the book. The author's careful to point out that the book concerns England only, although its present borders were obviously not the same during the historic periods described. Ireland, Scotland and Wales, of course, had different legal histories, and also, in Derek's words, surviving sources ensure an overemphasis on England's south and east. And I'm recording this after the general election in May 2015, and I think some people might see what I'm getting at there, because obviously the difficulty is that the sources of information we have, generally speaking, have been in the south, but of course we do have other areas we can call on as well. Now, the research evident in the creation of this book drives the author's stated purpose very well indeed, and that is to increase understanding of the ways in which people recognised, classified and processed systematic methods of dealing with conflicts in the hope of ending strife. But will this level of understanding help contemporary arbitrators and mediators in their efforts to deal with contemporary conflicts? One can only hope so. To know about the past might or might not help to solve the problems of the present, and there might be no direct advantage, the author admits, but it would be enough if it clarified our minds and saved us from avoidable and repeated error. Let me conclude by saying one thing in particular is as certain now as it was in the Anglo-Saxon period, and that is that an arbitration process should leave the loser as happy with the result as the winner, and presumably vice versa. Now, any barrister, counsel who've been involved, as I have, in doing mediation training and involved in this, the essence of part of this is that the parties, when they have gone through the process, will go away without having some form of continued grievance. And that, I think, is what is coming out, not just of what we're doing today in the 21st century, but the way this has been going on actually for centuries. If one thinks about it, it's the most constructive approach that you could possibly adopt. Let me go on. Whatever the long, now forgotten case, for instance, of Woolston and Leofric, on what they were arguing about, as an example, their friends agreed that it would be a good idea if Leofric would have been satisfied with that amount owed if the decision had gone against him, as it would for Woolston. So you see, the whole aim, even going with that example, is the fact that they go away in a happier frame of mind, feeling that justice has been done. Because remember what we deal with today, both in the courts, the tribunals and in arbitration processes. We've got people who want their day in court. But at the end of the day, even if they lose, I hope with most clients they will understand the reasoning behind why a decision has been made, even if they don't like it. But you see where we are coming from as advisors on this, and I think this book is of great benefit to lawyers as well as to historians. As I say, it's a scholarly and fascinating book, full of such gems as the case of Woolston and Leofric. And if you want to read more, read the book, particularly if you are professionally involved in any aspect of dispute resolution, because I think, apart from anything else, it gives you a much better perspective on what we do. And after all, as I've said, I'm recording this in the middle of 2015. We're probably going to have quite a lot more mediation and arbitration, whether we like it or not. And it does actually work, I have to say, it does work. This is the book. Again, there's the back of it. Lovely cover. I'm just opening it in the middle. This is about Alfred the Great. Lovely man, very important person. Winchester features in it, of course. And then you've got going up to the actual Norman conquest itself, and then beyond, after the conquest, up to 1154. So this gives you a general feel for the book. It's very interesting front inside cover there, which looks very much part of that original arbitration award. And there we go, that is the book itself. And just to remind you at the back, great index. And just I really did like the chronology. I thought that was particularly helpful. It's not very long, but it really is interesting, because it's so, rather like abbreviations, it's so easy to forget the actual dates, and that actually will refresh your memory. Thank you very much to Derek Roebuck and to the publishers for what is a great read. I like history and I like law, so it's made my day reading it. Thank you very much indeed. Bye-bye.